Happy day. Welcome to M.O.P classroom. I am Dr. Sasikala Devi, Department of Commerce General. So today we are going to look into the different concepts under Indian Contract Act 1872. So let's see the concepts under Indian Contract Act. Let me start off with the definition of what is a contract. Contract is an agreement that is enforceable by law. So we can divide the definition into two, that is agreement plus enforceability. So let me tell you what is an agreement under section 2 subsection E. It's every promise and every set of promises forming consideration for each other. So there are two parties involved, minimum of two parties involved for an agreement, and they exchange promises between them which forms a part of consideration for each other. So that is defined as what is called as agreement. So let's move on to the next part of the definition of contract, enforceability. Now what is meant by enforceability is parties to the contract can sue and can be sued. So let's move on to what is meant by a promise. So when a promise is made by one person to another person and the other person gives his assent to the particular promise, you say it's an accepted proposal. So let's see the definition of what is a promise. According to section 2 subsection B, when a person to whom proposal is made signifies his assent, the proposal is said to be accepted. So a promise is converted into an accepted proposal and therefore that leads to an agreement. So in general, I can tell you that an agreement will lead to promise, that will lead to accepted proposal. Now let's see the essential elements of a valid contract. These are all the essential elements. In this session, we are going to see all these in brief. So number one, offer and acceptance, intention to create legal relationship, consideration, consensus ad idem, capacity to contracts, free consent, legality of object, possibility of performance. Now let's start off with the first essential element of a contract, offer. Now what is an offer under section 2 subsection A? When one person signifies to another their willingness to do or abstain from doing something is called as an offer. Now when an offer is made by one person, the person making the offer is called as an offerer and the person to whom the offer is made is called as the offeree. That particular offer is made by one person, the other person needs to give his assent and that is called as the acceptance. So let's move on to the next definition as to what is an acceptance. According to section 2 subsection B, when the person to whom the offer is made signifies his assent, the proposal is said to be accepted. So let me conclude, an agreement is basically made up of offer and acceptance. So let me go on to the next concept under contract. As I told you before, a contract is basically consists of agreement and that agreement will definitely lead to obligations. So obligations, there are two kinds of obligations. One is social obligation and another one is legal obligation. The agreement which gives rise to a legal obligation is only enforceable by law. The agreement which gives rise to a social obligation is not enforceable by law. When I say not enforceable by law, it means it's not a valid contract. So let me explain with an example as to what is a social obligation and what is a legal obligation. Say two parties enter into an agreement to sell a car for a price of 1 lakh. So the parties to the contract are say A and B. A is the seller and B is the buyer. So the subject matter here is selling a car. This is a valid contract because this agreement gives rise to a legal obligation. So let me give an example for a social obligation. A and B are friends. A invites B for a party but could not accommodate B due to heavy crowd. Therefore, this is an agreement between A and B but gives rise to a social obligation which is not enforceable by law. So B cannot sue A just for not accommodating him for the party. So therefore, I can say that a contract consists of agreements, but not all agreements are contract. So that means all contracts will have agreements, but all agreements cannot be contracts because agreements can give rise to a social obligation as well as to a legal obligations. Now let's go on to the next concept which is called as consideration under section 2 subsection D. When at the desire of the promiser, the promisee or any other person has done or does or promises to do or abstain from doing something, such act or abstinence is called as a consideration. Now let me go from a technical point of view. Consideration is otherwise called as quid pro quo. It means something in return. So when an agreement is formed between two parties, Both of them exchange promises and that becomes consideration for each other. Now, I can give you an example. A and B are parties to the contract. A agrees to sell a two-wheeler to B for 50,000. So, A delivering the two-wheeler to B becomes consideration for the buyer B, and B paying the price of 50,000 becomes a consideration for A. A consideration can be an act or an abstinence or a forbearance. So, when I say it's an act, a consideration can be to do a particular thing, but whereas abstinence is refraining him from doing a particular act also is considered as a consideration. Now, coming to doctrine of privity of contract, it means that only parties to the contract can sue and can be sued. So, a stranger to the contract cannot sue and cannot be sued. Now, let's go on to the next concept. Consensus ad idem under section 13 refers to meeting of the minds or mutual agreement between parties to a contract. Let me give you an example here. There are two parties to a contract, A and B. A is the seller, B is the buyer. A is the owner of two horses. The name of the horses are Raj Hans and Hans Raj. So, he is planning to sell the horse named Raj Hans to B. B also agrees to pay 5,000 to buy that particular horse. But the buyer B thinks that he is going to buy Hans Raj. So, there is no meeting of minds, meaning there is no consensus ad idem. So, therefore, that particular agreement or the contract stands invalid. It is not a valid contract just because there is no consensus ad idem. Next essential elements of a valid contract is capacity to contracts. The parties to the contract shall be capable of entering into a contract, then only the contract stands valid. If they are incompetent to enter into contracts, then the contract stands invalid. Now, let's see following persons who have been declared as incompetent to enter into contracts. Number 1, minors. Number 2, persons of unsound mind. And number 3, persons disqualified by law. Now, who is a minor? Minor is a person who has not attained the age of majority, that is 18 years, is being declared as a minor. Now, who is declared as an unsound mind? A person who is a lunatic, who is an idiot, and who is a drunken. Third one, a person who is disqualified by law, who is not supposed to enter into contract. So, these people are declared as incompetent persons. Now, let's go to the next essential element of a valid contract, which is free consent. So, what is consent? Basically, it's an act of assenting to the offer made. So, if there is no free consent, then that is not a valid contract. So, you need to have a free consent, the assent to be given freely without any flaw in free consent. So, let's see what are all the flaws in free consent. Number 1, coercion, undue influence, fraud, misrepresentation and mistake. Now, coercion is one particular person compelling the other person to enter into a contract or threatening him to enter into a contract is called as coercion. Undue influence, one particular person dominates the other person and makes him to enter into a contract, that you call it as an undue influence. Let me explain the next one, which is fraud and representation. But before explaining fraud and representation, let me tell you what is representation of facts. When an offer is made by an offerer, he places certain representation of facts regarding the subject matter. So, the facts which is given by the offerer shall be true. If in case there is wrong information being given, it may be given intentionally or it may be given unintentionally. If the information is wrongly given, intentionally given, then you refer that as fraud. If it is unintentionally given, you refer it as misrepresentation. Now, let's move on to the next flaw of free consent, which is mistake, which is an erroneous belief about the subject matter by both the parties. Now, let me explain with an example. A and B are parties to the contract. A is a seller of car for 80,000 and B is the buyer. Now, the car is situated in a garage which is in Salem. The seller is in Chennai, the buyer is in Trichy. A and B assume that the car is in a mercantile state, but unfortunately there is a fire accident in the garage and the car is destroyed. Now, both the parties believe that the subject matter is in a good condition. So, this is called as a mistake, which is erroneous belief about something. So all these 5 are referred to flaw in free consent. So in case the assent is given by either of these ways, then you say that there is a flaw in free consent and therefore it does not result to a valid contract. We go on to the next one, legality of object. The object of that particular agreement or the contract should be lawful and not illegal. Now let me tell you what are all the unlawful objects of a contract. Number 1, if it is forbidden by law, meaning the law does not permit that particular object or the subject matter to be as a part of the agreement. Second one, if the particular object is fraudulent, if it involves injury to a person or a property of another, and if the court regards it as immoral. In all these cases, that object is not lawful and that will not lead to a valid contract. Thank you for watching. Like, share and subscribe to M.O.P Classroom for more such interesting videos.